So hello guys, welcome back to another video. So in this video, I'm going to cover the chapter 7, which is the law of insurance, leasing, and hire purchase and loans. So if a business wants to get a loan, so what sort of things that they want to follow? So during a contract. So this is also a type of a contract that you do between banks and finance centers. So this contract, so we're gonna go through in depth about uh, what sort of contracts that you make, that you do, what sort of things that you must fulfill in order to get these insurance, leasing, hire purchase and loans, and what sort of remedies are available, what sort of damages are available if things has been breached by both sides. So let's get into it. Yes, so insurance. So many people know that what is insurance. Insurance is, in our terms, says that that you pay a particular company in order to get compensation in pretty much in difficult times. Such as life insurance, medical insurance, travel insurance, and most lonely people nowadays they do is vehicle insurance. But let's look at this. So it's based on the above description, the contract of insurance. It could be seen that there are three main types of elements in the contract of insurance. So these are premiums. For the payment consideration only as premiums, so assured to get a right of receiving sum of money upon the occurrence of a specified event. So the premium insurance. So uncertainty, there must have a degree of uncertainty about the occurrence of the specified event. And finally, insurable interest. So the assured must have an insurable interest at the time of making the contract. Insurer interest has been described in the section 6 in this chapter. Yes, so what is the difference between contract insurance and contract of wagering? So insurance is taken protect what is yours, but in gambling you're trying to make a bargaining or winning. So in insurance you must have an insurable interest in the thing you insure, but in gambling you can bet on anything. Courts will enforce a contract of insurance but not a gambling contract. Generally you cannot insure the same thing or risk of two insurance by gambling on both sides. So what is the applicable law? There are all the two laws in Sri Lanka applicable, mainly two laws. The main two laws, which are English and the Roman Dutch laws. So in English law, they governs life, fire, and marine insurance. In Roman Dutch law, governs all other types of insurances. So it says, but if the Roman Dutch law is not clear on any matter, then the English law principle will be applicable by the courts. Yes. So if a one law doesn't have criteria, it will look on to the other criteria, other laws of criteria. So the main categories of insurance: indemnity and contingency. So indemnity is you provide against loss or damage, make a good compensation at a loss. So vehicle insurance, if you get accident, the insurance will cover it and you pay a yearly fee for that. Contingency insurance does not provide an indemnity, but it provides a payment on occurrence of a contingent event, so such as a travel insurance or some sort of insurance that you taken of an event, or you building you insurance your house or your building, but during a natural disaster the insurance will cover up your cost. Concept of indemnity and subrogation. So in this section we will discuss two main topics. So what are the two main topics? So we get concept of doctrine and subrogation, and so we got classification of insurances. So sorry. Yeah. So so these are the two types. So we got life insurance, like I said, general insurance, accident, burglary, things like that, and marine insurance, and life insurance in contract of assurance. So we get life insurance different all sort of types. So we get pre-agreed sum of money and death upon a person whose life is insured, and the terms of insurance and assurance is insurance law means the same thing. There's no distinction between these two terms. So insurance and assurance is the same thing. I will insure or I will assure. That means you have taking the responsibility, you know. So that's how it is. So we got general insurance, fire insurance. If something caught on fire, your house, your building, your office, there will be certain, indemnity will be paid. Yeah, we got case Harris versus Poland. So Harris had obtained a fire insurance policy to cover her jewelry. One day she hid this jewelry in a grate under the coal. Subsequently, had forgotten this, she lit the fire. As a result, the jewelry was damaged. Harris could recover the damage from the insurers under the fire insurance policy. Interesting, because you pay some sort of a fee in order to insure your things, you know. So you are entitled for any that kind of insurance, but there are certain policies, blah blah blah. If you break the law in such, you will not get it. But uh, but if you go to courts, the courts will look into your side. It's kind of a tough way to collect the money, but finally, most probably, you will get your compensation. So average clause in fire insurance. So what is sort of an average law? Uh, what you mean clause says an average clause incorporated in the fire insurance policy is the effort uh, of an average clause would be that if the property is being insured when undervalued in the policy, and if such property is destroyed by fire, the insured will not receive the total amount of insured for. He will receive only an amount proportionate to the amount insured. Accident insurance. Insurance is not a contract of indemnity. It is an agreement to pay a specified amount of money on the happening of certain events. Generally, the payment of the specified event sum of money would be in the following manner. So payment when insured dies. In the event that the assured dies in an accident, the sum assured will be paid to the executors of the deceased. Payment in partial or total disablement. In the event of a partial or total disablement due to an accident, a lesser amount of money will be paid. Payment when unable to work. In the event an assured is unable to work, weekly sum of money will be paid. So yeah, and got marine insurance. The contract of insurance refers to a contract where the insurer undertakes to indemnify the assured against loss incident to a marine adventure. So therefore, it could be said that the marine insurance is a contract of indemnity. So there are different kinds of um, marine insurance policies. So got voyager policies. You know, um, if some people sitting on a voyage, such as finding oil, gas, things like that, and places. There's a policies for that, and we got the time policy. So in time policies, the contract of insurance for a definite period of time, the duration of the policy is defined as a period of time. So, let's say for 1 year, they put a time policies of a marine insurance. So within this year, if something damage occurs, so if there's some sort of a damage occurs, some sort of things happened, there's some sort of insurance. But if that time got expired, you are no longer they are no longer entitled for the insurance claims. Got valued policies. So it means subject matter is being insured. some sort of a agreed value. So unvalued policies. Got subject matter insurance is not assessed but is left to the ascertained subsequently subject to the limit of the sum of insurance. Floating policies got without naming the ship and other particulars. The name of the ship and the other particulars will be defined later through a declaration. So warranties in marine insurance. It's got different legal effects. So warranty in sales of good of contracts. In marine insurance, you have, if it's to be material or not, the warranty must be exactly complied with. The effect of non-compliance is that it will be discharged from the insurer from liability from the date of the breach. So implied warranties in marine insurance given below are the implied warranties in marine insurance. In this case, the voyage policy at the commencement of the voyage, the ship is seaworthy for the purpose of the particular adventure insured. So in the case of voyage policy, where the voyage is to be performed in stages, at the commencement of each stage, the ship is seaworthy for the purpose of that stage. So, ship to be seaworthy at the commencement of each stage of the voyage, Greenock SS Company versus Maritime Insurance Company Limited. So, it says ship was insured for a round of voyage from UK to USA and back. The ship left one port with enough coal to go to the next port of the coal. So therefore, to prevent the ship being a total loss, some of the ship fittings and spars has to be burned. So as ship was not fit to meet the ordinary perils of the voyage, when she left on the port to the other, there was a breach of an implied warranty. Therefore, the insurers were not liable to pay for the value of the fittings and spars so destroyed. Yeah, so that's how it is. It's because that the voyager policy on goods or others are movable at the commence of the moment. The ship is not seaworthy as a ship, but is also reasonably fit to carry the goods destination contemplation by the policy. So where the policy has attached the ship is in the port, the ship shall be reasonably fit to encounter the ordinary perils of the port. Thus, an adventure is a legal one, it will be carried out in a lawful manner. So loss and load is of an abandonment. So a loss, partial loss, means something has been partially lost. A total loss, so it can be two kinds: actual loss and constructive loss. So an actual loss is a subject matter is insured, that is destroyed and ceased to be the insurance against. Uh, as an example, actual total loss is presumed when a ship goes missing and after a reasonable time no news of her has been received. So, so the case law was when goods are destroyed. So Asfar versus Blundell is an example regarding that, and so it's called cost of salvage is greater than loss, and the cost of repairing is greater than the loss. So that's how it is. So we got notice of abandonment. So insurance clearly indicates that abandoned under condition to the insurance subject matter of the insurance. Notice may be the written or verbal form. It is not that the accepted admitted liability for the loss on the abandonment of the subject matter. The insurer is entitled to take over the assured interest in whatever remains of the subject matter. Measured of indemnity in marine insurance. Uh, if there is a total loss on valued policy, the measure of indemnity is the sum fixed by the policy. If there is a total loss on an unvalued policy, the measure of indemnity is the insurable value of the subject matter. If there is a partial loss to the ship, the measure of indemnity is as follows. If the ship has been repaired, the cost of customary deduction, which are generally 1/3 of the cost of replacing things. So these are the some sort of how to measure the indemnity in marine insurance. There are a few steps, and we got insurable interest. It means that person seeking insurance will benefit from the preservation subject matter insured by affected by its loss. I got interest relating for life insurances. So life insurance policy become null and void, absence of an insurable interest. Given below there are some case laws, things like that. So what are the case laws? Insurable interest for creditor in life for a debtor. So Dalby versus India and London life assurance. They say that a creditor has an insurable interest in the life of his debtor up to the extent of the debt. So the case law is insurable interest of the debtor in the life of a co-debtor. Got Banford versus Saunders for that. So case law for insurable interest is own life. Griffith versus Fleming. Case law for insurable interest for sibling. Everson versus Crooks. So yep. Parent and children. Howard versus Refuge Friendly Society. Employee and employee. Hebden versus West. Yeah, and it keeps going. Got case law for shareholders. We got, yeah, and that's it. And this, so insurable interest in relation to marine insurance. So get lender money of the bottomary respondentia to the extent of the loan. Bottomry, this is a pledge of the ship at the flight to secure a loan to enable to continue the voyage. So the master of the crew extend their wages, the person advancing freight, the the mortgage, mortgage, and the mortgagee. So, so the mortgager, I think, it's a spelling mistake, and the mortgagee, how it is. And so we got principle of ubriemi, ubriemi fide, utmost good faith. So bona fide, it means good faith. So ubriemi, fide is utmost good faith. So a very important aspect in contrast for an insurance, that is duty imposed by person applying for the insurance cover to exercise utmost good faith in all his declarations to the insurers. In Latin, utmost good faith refers to as uberimi, uberime fide. And this principle is uberime fide means that the person seeking insurance owes a duty to disclose that the insurance, every material fact which he knows, that he ought to know about the insurance, so that the insurer can properly evaluate the risk that he is undertaking. Failure to disclose this material, person seeking insurance give the insurer the right to reject the payments policy, such as failure to make the policy voidable. So got material facts. So that means that in some areas the judgment decide that whether the insurers that they willing to accept the risk. So in fact fixing it to a premium insurance, that means mostly premium insurance you pay a much more higher than the other insurances. So in premium insurances doesn't matter if there's a risk involved, so a lot of risk involved of the job that you do, that if you go for premium insurance it covers pretty much all, including death, which is your family members can compensate it for, can claim the compensation. For non-disclosure of material facts, so the person wishing to obtain insurance has to fill out an application or proposal form given by the insurance company. So you got failure to disclose a material fact. London Assurance versus Mansell. It's got failure to disclose a material fact. Case number 2, Looker versus Law Union. It was held that at this amount of the non-disclosure of material, the insurance company could refuse to honor the policy. So disclose material in fire insurance. We got Woolcott versus Sun Alliance, and non-disclosure material facts of life insurance, mutual insurance versus Ontario Metal Products. We got misrepresentation of material facts. So irrespective of whether the misrepresentation was fraudulent or innocent, the insurance company can refuse to pay the insurance claim if the material fact has been misrepresented. So the case law is innocent misrepresentation of a material fact. Got accident insurance. So it's O'Connor versus BDB Kirby and Company. Yeah, let's read this out since this is a very common during in the Sri Lankan environment as well. So in filling out an insurance policy application form, O'Connor mistakenly stated that his car is generally parked inside a garage at his home, but actually the car was normally parked at the night in the street outside his home. Eventually the car was damaged when it was parked on the street, and he claimed for the damages for the insurance policy. Even though the misrepresentation of the fact in this case was not deliberate, the insurance company was entitled to reject the claim. So yes, exactly. So when you are filling out an insurance application form, you have to be accurate. You have to be things like that. You have to have a copy of it. Make sure that if there's a things that has been uh, let's say that you put a you put a fire insurance for your house, and suddenly your children burned the place down because some sort of an experiment that they have done, but in the clauses says that if your fire insurance clauses say that not uh, this fire things has to be happen on a some sort of a mistake, uh, some sort of a natural event, not by a human mistake, things like that. But you have to be very cunning in this situation, but you have to tell that it's purpose of a natural event, such as a gas got burned, overburned, things like that, a gas pipeline has been damaged, and there's a fire electrical shortage. You have to make it up for it. And if you say straight away it has done by my children as mistakenly, the insurance policy can reject the claim as well, because there are so many exception clauses in an insurance policy if you sign it. But please make sure you read them all. So assignment of an insurance policy called assignment of life insurance by endorsement of the policy of the specific form must be followed by notice in writing to the insurer. Assignment in fire insurance, yes. Got marine insurance. You got yes. So the hire purchase. So hire purchase is a popular method of installment credit, frequently used in the business world. The hire purchase, uh, the user is given an option for purchasing the good by paying a stipulated amount. So the applicable law is the Consumer Credit Act number 29, 1982. This act mainly defines the regulates the duties of parties in relation to hire purchase agreement. In addition to the act, it is a Roman Dutch law which is applicable common law for hire purchase. Yes, so the hire purchase comes derived from Roman Dutch law. And what is a hire purchase? So it is an agreement under which goods are led on hire. Under this agreement, the possession of goods delivered by the owner to another person in the condition that such person pay an agreed amount of periodical of installment. So you take things on credit. So mostly farmers, a chicken farm, poultry, and if you take a hardware, they take oils, such as equipments, things like that. They give on credit, they say it's wholesales. They wholesale it, and the retail shop keeps a margin of profit, and they sell it through that. So it's on good faith that they're giving it. They sign a contract worth of, depends on the contract, let's say 1 million rupees. So they give 1 million worth of goods, and every month you have to pay some sort of a fee that amounts to 1.2 million, but the retailer must keep a profit, and also he is bound by the contract that he has to pay a monthly installment. So says as who is an owner, person who has owned the property of goods and other owner's liability under the agreement has been passed an operation of the law. So who is the hirer? The accessor, person who has obtained the possession of the goods from the owner. Passing the property of hire purchase. So we got completion of purchase in the manner provided for an agreement. Yes. Obligation of the hirer to comply with the hire purchase, to give information, to hire as duty of keep his office position, to make use of the goods, take care of the goods, not to defraud the owner of the goods. So that is the hirer. That means the person you are is that the person who is buying from the owner. So they have to be complied with the agreement. They have to be honest. They don't have they should not make fraudulent acts against the owner. So got rights of the hirers too. So Purchase of the good anytime the balance due on higher price with a rebate. To terminate the hire purchase agreement at any time. Yes. To appropriate payments in respect of two or more hire purchase agreements with the same owner. To assign his rights obligations under the hire purchase agreement to another party. They do can. When the owner repossesses a good and sells it, the hirer has a right to recover any excess of monies left after the owner's recoveries on duties. Exactly. So, hirer always can repudiate the contract if he sees that it is not it's not redeemable, and it's making a huge loss for them. So they always can immediately repudiate, and they pay some sort of a things that has been left for the owner and return the goods. And they also can do it on the other way. They can take it some sort of money from the owner, and they can give the goods as well. So the obligations of the owner to supply copies of the hire purchase agreement. Of course, the owner has a duty to supply information regarding hire purchase transaction to the hirer on a request made by the hiree. Rights of the owner to terminate the hire purchase agreement when there's a default in the payment, such as breach of an agreement. To retain installments, the initial deposit paid by the hirer, and to recover the balance due, if any. To recover the possession of goods, to provision a restriction of the acts, to claim damages if he loss he has suffered, to assign his right and obligations to hire purchase agreements to another party. Simple. So leasing, Finance Leasing Act number 56 of 2000. So we got leasing is the most commonly known external financing method to our business world. So the basic company is that the profits are made through and use of an asset, and not is by an ownership. So applicable law, so governing law, leasing in Sri Lanka, financing is this act. The concept of leasing, finance leasing is defined as an agreement between lessor and the lessee. Uh, yeah, so these are who's a lessee, transfer the right of the possession of an equipment on the lease. Lessee is defined as the person who is acquired the rights of the possession, use, and equipment under the lease. So, who's a supplier? What is an equipment? Lessor rights for an undistributed possession. Supply and deliveries, because supply and delivery of the asset, and you got non-delivery of the lease asset. Got acceptance and return in equipment, acceptance of equipments, return of equipments, default by remedies, default by leasing, remedies available for the lessor, the recovery of possession of leased, of without a court order. So recovery through a court order, so has to be done some sort of an assist. So normally leasing and hire purchase courts goes in the district court of Sri Lanka. So these things are civil, based on civil law, and called hire purchase, we call it DHP, district hire purchase. We call it DLM for leasing, money recovery, DMR, things like that. Leasing money is DLM, and money recovery is DMR. So these kinds of court cases are very common, and they are flooding to the courts. So loans, loans and security got established by credit providers such as banks, finance companies, etc. They lend money to their customers by keeping some kind of security to settle the repayment of money, so to lend. So main types of securities by the lenders. So normally we say that by leasing, you give a property for them, and you take some sort of a money, you value the property by giving some sort of valuation report. Let's say you need 2 million rupees from the bank, and then you give a land and value up to 2.2 million of value, and you get somewhere between 1.8 million. Fair enough. And you take the money, and they have the right for the possession of the land until you pay off your um, your leasing. You means you the money that you have borrowed. So what sort of securities that you give? So I mentioned before land. So mortgage is an asset lent, life policies, limited shares of a limited liability company, guarantees from third parties, performance bond, trust receipts, imported goods and goods to be exported. So mortgages, Mortgages Act number 6 of 1949 is a subsequent amendments. So when you say mortgage is normally referred to as houses, but so there are some sort of things. We got mortgage is a security furnished by a person for repayment of loan. So these are the things what is defined. So let's say an example: a house owner uses land as a security to obtain loan from a bank to be repaid in 10 years. The bank will hold the land as security until the full loan is applicable interest is paid. Yes. So parties to mortgage, mortgagor and mortgagee. The mortgager is pretty much the buyer. The mortgagee is pretty much the owner. So, as I said before, mortgager is a person who borrows money to buy a property. Mortgagee is a person institute that lends money to buy the property. So the mortgage bond. So you normally sign the mortgage bond. It can be a deed of mortgage, things like that. So let's say, and there's some sort of a time period. So it depends. Minimum they take 10 years, but 10 years can go up to 20 to 30 years as well. Depends on your age that you are making doing the payment for. Yeah. So recovery of a default, section 2, that hypothecary uh, hypothecary action. So get action to obtain an order declaring the mortgage property to be bound and executable for the payment money due upon the mortgage, and they enforce such payment by judicial sale of the mortgage property. So according to the mortgage file will file an action in the district court where the mortgage of property is located at, or where the mortgage bond has been entered into, or whether there's a dependent resides it. So one of the main elements of hypothecary uh, action is all interests should be notified. So person entitled to notice is in section 5. So several parties to person who entitled for the notice of their action if person who has interest in the land when the mortgages affect such an interest. Yes. So these are the things. So section 8 says the attorney at law of the plaintiff has given the declaration specify the following. So these are the normal laws, so got so the district judge is upon the zoning, and registrar of the company also, they'll be entitled if there's a court case. So it goes under civil procedure code as per section 1, section 10, because section 12 also. So registration of lease pendants in this side of action. Registration of lease pendants is mandatory, and without lease pendants being registered, no further action can take place. After lease pendants is registered, the action will continue in the manner that an ordinary civil action. So sale under this hypothecary action, property is liable for under sections 46 is there. So characters and collaterals. So so it's very common law it's in Sri Lanka that when you take a mortgage, when you take a some sort of a vehicle, that when you lease, you take a loan, they require guarantors. At least two guarantors are required, but they have to be the most you know what you call most trusted people. Things has to be more trusted, because if the owner, the mortgager doesn't pay, the guarantors has to pay. That's how it is. So So yeah, so the guarantor, principal debtor, lender or creditor. So there's the three types. So what is the applicable law? Roman Dutch law, which is the common law, and the prevention of frauds ordinance. That's how it is for the guarantors. So the main requisites for the guarantee, the main obviously is has to be written and signed by the guarantor himself. The common law privilege of the guarantor is unless he expressly renounces that these privileges, then apply to the guarantors. These privileges these are the privileges. And yeah, debt recovery, parate is means immediate. Parate execution means debt recovery where the mortgagee has invested the power to sell the mortgage property with the recourse to the courts. So let's say the mortgagor takes the money and refuses to pay or unable to pay the money, and what they can do, the mortgagee can go to courts and obtain a court order and sell the land that has been mortgaged, the land, the house, anything, the shares of the company, anything that they have lent upon, you know. so so this can be do by debt recovery, uh, special provision, and the recovery of loan by banks. So these are the two acts. uh, so we get interpretation of this bank act. Lending institution, what sort of a lending institution? So it had to be finance companies or a bank, or it can be a bank, it can be a development bank, it can be a commercial bank, it can be a finance company. So it's what is a debt? So actions by lending institution for recovery of debt. So copies of instrument, agreement, or document will be sued upon the filed. That's how it is. So decree, section 5 says decree shall be ordinance shall be a defendant registered post for the addressed institution through the employer, fiscal of the court, process of the officer will also apply. So normally if there's court case, they will obviously send summons, nices, letters by registered posts. So defendant not to appear as show cause except with leave. It says that section 61 shall not appear as a cause against a decree unless an obtained leave to appear as a show cause. Section 3. So we got so if the district court cannot do a leave grant, they can appeal for the civil appellate high court to obtain a specific order, things like that. And so criminal liability, section 25 says that according to this is draw checks knowing that there's no sufficient funds to incur such check. So this is a fraudulent act. Normally you say that giving checks and checks has been bounced, so that means it's a criminal fraudulent act. Either they can go for criminal proceedings or they can go for civil proceedings, so you even can go to jail that if you given false checks that is mentioning that if your account does not have sufficient funds uh, and the check bounce back, they can go to courts and they can put you into jail. So normally this kind of things go starting from the magistrate court. So yes, normally, so the OIC CID versus AC Soris, majority of judges decided the provision of Section 25 will not be confined to lending incidents, can be caused due to individual also. So the says that so it has gone to the Supreme Court. So Jai Singh JS, which is the judges. Uh, Let's say that's a question which arose that the determination of in this case was whether an institution which is not lending institution within the meaning of the Debt Recovery Act invoke the provision of Section 25(1). Thus, when a check is drawn by a party in violation of provision of the section, the petitioner respondent issued the checks of value of 4.6 million rupees without sufficient funds with the Udapalata Multipurpose Cooperative Society. The said checks was issued by the accused as payment of purchases of seed potatoes, and the said chase has been dishonored. So the respondent petitioner filed charges in section 25 of the Debt Recovery Act. Magistrate Court in Bandaravela preliminary objection was raised in behalf of the accused. The fact that it does not warrant presenting a charge in terms of section 25. The learned magistrate overruled the objection and fixed the matter for a trial. Aggrieved by the said order, the accused invoked the revisionary jurisdiction. The Provisional High Court to order set aside the learned High Court judge while refusing to issue notice. They held that in terms of section 25 subsection 1, section 1 subsection A in the act, so offense to draw a check without funds or without sufficient funds, that the nature of the person on whose favor it was drawn is immaterial for prosecution under this section. So the agreed by the said order, the accused invoked the revisionary um, jurisdiction of the Court of Appeal. The Court of Appeal held that the Udapalata MPCs does not fall within the interpretation of the meaning lending institution, and therefore no relevance of prosecution institute in terms of the provision of the Act. So respondent petitioner filed special leave appealed regarding that, so they are not happy with the Court of Appeal decision, so they appealed. So respondent petitioner was submitted that part 5 of the constitute criminal responsibility in respect of any person knowingly draws checks dishonored by bank. Learned deputy solicitor part 1 for part 5 establishes criminal liability on a person knowing drawing checks which is dishonored by a bank or wants of funds. So we get with reference of interpretation statute by Bindra was submitted in the construction that section 25 of the Act is clearly not ambiguous. On behalf of accused petitioner respondent, it was submitted that section 25 applies where the transaction has been lending institution of the person. Section 25, which is no application in respect of transaction entered into between two private persons. So majority of the bench says that self-contained and exist of devoid of any ambiguity and given effect to without resorting to any other provision, and learned judges were also with the institution of an action. Part 1 of Debt Recovery Act has no relevance whatsoever to prosecution instituted under section 25 verse 1. So Tilikavardhana Justice in her descendant. So, in her dissenting judgment, it held that this section must be cautiously interpreted under the whole spirit of the Act to mean that the procedure was optional to the lending institution, and whether the procedure was civil or criminal, it was one was that restricted to transactions involving lending institutions. The intention of the legislature was clear to assist the lending institution to have be more effective recovery procedure and to deal with such defaulters who committed offences under the Act, and was specifically enacted to assist lending institution dealing with the defaulters. So normally in the Supreme Court they have taken a chance for the mortgager because the section 25 verse 1 has not interpreted properly. That's the argument of the bench. Yes, so interesting case. This is some sort of a leading case but taken by many defenders regarding their mortgage issues. Recovery of loans by banks. This is the Special Provision Act number 4 of 1990. So it says what is a bank? There are a few acts that has been mentioning that. The concept known as parrot execution. So to apply the provision with the statute, three requirements must be fulfilled. There has to be a loan secured by the mortgagee, guaranteed by the bank. A bank within the meaningful meaning of this act. The sum defaulted on the loan has to be more than 5 million rupees. So, Nanayakara versus HNB. Supreme Court, appeal number 53 2017. So that is the court case for this. Uh, so got registration of the address of the borrower, section 2 has to be fulfilled. Action by board with default is made, the section 3 authorization of sales of mortgage property, section 4 notice of resolution, section 8 notice of sale, section 9 payment before sale is section 10, upset prices section 11, and classic case was Samantha Parajava versus Sampath Bank 2005. Default in respect is one of several loans in the same property. Recovery of expenses and cost incurred by the bank. Payment of excess section 14. Create certificate of sale section 15. Haji Omar versus Vikramasinghe. There is a certificate of sale. So order of order for delivery of the possession. Section 16, cancellation of sale is section 17, 18 and 19. 18 goes for property has been sold by the purchaser on behalf of the bank and to resell the property. Section 19 imposes limitation to the bank should not keep the property for longer period than necessary. So offense of section 20. So what will happen if not paying the mortgage or a criminal fraudulent is happened? uh, Imprisonment not exceeding 6 years, so fine not exceeding 5,000 rupees, or both it can be upon conviction by a magistration court. So if you go for criminal proceedings, you will get a fine of 5,000 rupees and a 6 years of imprisonment. For proceeding when borrower is dead, obviously District Court of Colombo, the property is mortgaged by the bank is situated. If the court is satisfied that the grant is probate or the issue of letters administered is likely due to be unduly delayed, the court shall appoint a person to represent the estate of the borrower for the purpose of this section. So yeah, the bank cannot sell as it possible because there are other if the mortgage has been mentioned by their widower and their sons, the family, they can also come into this place as well. Parrot execution as we came again, so without recourse to the court. Normally it's normally under Roman law. And so third party mortgages versus parrot execution. When the borrower mortgages someone else's property, it is known as third party mortgage. When the borrower is and the borrower are engaged in two different mm, persons, it's known as parrot execution. So Ramachandran versus Had National Bank decided that parrot execution cannot be exercised on the third party mortgage. Exactly. So another HNB versus Jayavardhana says the Supreme Court decided that the decision in Ramachandra case regarding the third party mortgage will not apply when the borrower and the mortgagor are a company and its director. Exactly. So directors of a company who is benefited from facilities obtained by the company from the bank against mortgage of the property cannot hide behind the veil of incorporation and claim that the mortgage is a third party mortgage as contemplated in Ramachandran case. Exactly. So the interpretation is section 22. Board. What is a board? Board of directors. They are the management and the administrators of the of a bank. Exactly. So yeah. So that's all it, and this is the end of the chapter 7. Law of insurance, leasing and hire purchase loans, and I'll be covering chapter 8 on the next one. Until see you then.